The next matter to come before the court this morning is State of Ohio versus Edrick Mayfield. The state has waived oral argument this morning. You have 15 minutes to present the case, and we've read the briefs and we're ready to proceed when you are.
Thank you very much, Your Honor. May it please the court and the panel. Paul Adams on behalf of Appellant Edrick Mayfield. This is a case that from 2007. Somewhat germane, maybe eventually if this case sends it back to the common pleas court. This was either a home invasion or it was a drug deal gone bad. In any event, the events all took place within one household. It all took place within one period of time. No question the defendant and a couple others came in, and eventually the police were outside and there was some kind of standoff situation, and then ultimately Mr. Mayfield was arrested. And so that's how the case came to the court. It was resolved by the court with guilty pleas on May 31st, 2007. There was a written plea agreement on a standard form with not a lot of verbiage, and probably most significantly, nothing in the written plea agreement that would suggest a consideration as to whether the offenses of conviction were allied offenses of similar import. The court imposed consecutive 9-year sentences on robbery. They merged several robbery counts as to victims into one count. They did the same thing as the kidnapping, same thing as the felonious assault. The court imposed the 9-year consecutive sentences on the robbery and the kidnapping, and that's really the issue that we've now brought before this court as to whether or not there should have been some consideration from the court as to whether those offenses were allied offenses and whether they should have merged. There was no direct appeal. In March of 2014, we filed a motion to vacate in the trial court, suggesting that the judgment and the sentence were void on an issue as to whether or not Appellant Mayfield had been properly advised of his appellate rights. That motion was denied by the trial court. We did file an appeal. During those proceedings, the state took the position that the proper remedy, if any, would be a motion for a delayed appeal. So in light of that, we did file a motion for a delayed appeal in January of 2015. This court was kind enough to grant that in February of 2015. That, we considered, made the direct appeal of the motion to vacate moot, and that was dismissed then. So we are here on a direct appeal of the conviction and sentence that was imposed May 31st of 2007. And we're specifically arguing that the court should have, the trial court, should have considered whether the robbery conviction and whether the kidnapping offense, whether they were allied offenses. As previously mentioned, there's really nothing in the plea agreement that would suggest that the court considered whether they were allied offenses. Certainly in many cases they can be. We believe ultimately, if presented referred back to the trial court, that they will be found to be allied in this, as to these particular facts of this case. There was nothing in the plea colloquy to suggest. In fact, it's totally devoid of any discussion whatsoever as to whether or not these were allied offenses. There's just a recitation of what the sentence is going to be. The victim spoke. The court had a dialogue with the defendant, and then the court imposed the sentences. We believe that pursuant to this court's decision in Copeland, and then followed most recently in both of those cases this year, Lockhart, that when the trial court does not at all consider merger, that the proper remedy is remand with a direction to do so. And the state has agreed with us in the brief that they filed here with this court. So we would ask the court to remand this matter to the trial court with specific instructions as to consider whether or not the kidnapping and the robbery were allied offenses, and therefore whether they should merge for sentencing purposes.
And I don't remember, did you say that improperly? Did the attorneys file anything in regard to Rogers on this? I don't remember. Did you file supplemental authority in regard to the Supreme Court's decision, Rogers?
No, I didn't. And I think that, you know, my position on Rogers would be that I think that this appeal is still open. You know, as to whether or not Johnson applies retroactively.
Well, what I mean is Rogers is, I mean, an argument could be made that Rogers pretty much knocks you out of the box, meaning that you have to demonstrate plain error that you're prejudiced, and if there's nothing on the record, then you're kind of at a loss.
Well,
I mean, if there's something on the record and you can demonstrate, you know, hey, look, this is where allied offenses comes in, you know, and the court, you know, should look at that. But if you don't have any record of anything, I'm not sure where you go from there.
well, there's a record. It's somewhat limited. It's maybe more than normally you'd find in the sense that the victim spoke, and the court had a dialogue with the victim as to what the nature of the injury was, which certainly is one of the issues that would come into play in determining whether they were allied offenses.
Right, but that record has to demonstrate that they were allied offenses. That's the argument.
I understand that, and the state did not raise it. I didn't, as a result, respond to that argument.
Right, because this was all, you all briefed it before Rogers.
Mm-hmm.
So that's what complicates things.
The other thing that I'm gathering from the state's limited concession regarding the Johnson analysis is this idea that if the case gets remanded, that the sentencing is vacated, not just the limited remand to deal with the allied offense argument. Since this was a negotiated plea agreement, it has been the state's position in other cases, and it's alluded to in this particular case, I think, that when you have a negotiated plea agreement where we have other things merging and the total amount of the incarceration time is an agreement, that if that is found to have been flawed by the virtue of the allied offense error analysis not having been done, that the entire sentence is vacated on remand.
Judge, you know, I've seen language at the federal level. In fact, at the federal level, the U.S. Attorney's Office is incorporating specific language in that regard into their plea agreements that suggests that in the event a defendant down the road challenges, then the entire agreement, you know, is vacated. And there's no such agreement here. There's nothing to suggest that here. You know, it could be viewed as sort of a backdoor way to try to get around a deal, without a question. On the other hand, there's really nothing that I'm aware of that would preclude that. So maybe if it was it's somewhat dishonorable in the sense of just honor between the attorneys, I was not involved. I didn't represent him at the trial court level. But I guess my short answer to that is, even if it doesn't seem fair, I don't think there's anything that precludes.
Right, and that might be an argument to be made in the trial court after remand. It's just we're always mindful of what our remand instructions say, so that we're giving.
And Your Honor, point well taken, because one of the things I talked to Mr. Mayfield about, you know, along the lines of be careful what you wish for. We don't have a desire to reopen this entire case. Certainly the consequences could have been more severe. But I think that the issue is limited to just to those two offenses. So I don't believe that this reopens, that this vacates the entire conviction and sentence. I think it's just an issue as to which I think historically, precedentially has been done here, that the cases have been sent back just to consider the issue on the two subject offenses.
Thank you. That was responsive.
Thank you, Your Honor.
Thank you.
Pleasure to appear before you.
Thank you. Have a good day. It's not quite as hot out there.
No, we're getting there.
We're getting there. I know. I can feel it in here.
Thank you for your presentation today. The court will take the matter into advisement and issue a written decision which will be mailed to both sides, as well as posted on the Ohio Supreme Court website.